Okay, Ms. Flores, you can start us.
The Court of Appeals for the 8th District of Texas is now in session.
Good afternoon. We're here today on one case from Reeves County, Ola Kathleen Parker versus Michelle Elise Parker Jordan and Allison Renee Parker. Understand, Mr. Slavin, you will present for the appellants, and Mr. Kaiser, you will present for appellee. And so the parties understand we have had an opportunity to read your briefs. We have looked at the record, and we've had a discussion amongst ourselves about the case, if that helps you in your presentation. And so anytime you are ready, Mr. Slavin.
That please the court. Thank you, Your Honor. And just to be clear, I represent Kathy Parker, the appellant, and I'm also presenting argument on behalf of Allison Renee Parker, who is an appellee, but who aligns with her mother in this dispute. So I'll be presenting the argument for both. This is a family title dispute over what interest in a ranch a father gifted to his daughters through a 1998 gift deed. Now, without question, the father, Lloyd, gifted his daughters each a 1/16 fee interest in the Cottonwood Ranch that he received from his mother, Ruthie, in 1990. It is also certain that the 1/16 fee interest each daughter received is all Lloyd, their father, intended to give by the 1998 gift deed. And it is also, Your Honors, without question, that Lloyd never intended the 1998 gift deed to convey his daughters any future interest in the Cottonwood Ranch that he may or may not ever receive from his father's estate when his mother dies. These facts are undisputed and established. Elise, the appellee, agreed for over 18 years that she was only gifted a 1/16 fee interest by that 1998 gift deed. 2 years after her father Lloyd died in 2014, Elise changed her position and claimed for the first time that the 1998 gift deed also conveyed to her an additional 1/16 interest in the Cottonwood Ranch that Lloyd actually received in 2006 when his mother died. Please note 2006 was 8 years after that 1998 gift deed. Even Allison disputes her sister Elise's position. For years, her father Lloyd, Elise, Allison, and everyone else treated the disputed future interest as owned by her father Lloyd after he inherited it in 2006. Elise's mother, Kathy, the appellant, promptly sued to resolve this family title dispute once Elise made her new claim. To prevail here, Elise needs for the court to ignore these undisputed facts on her father's intent and her acknowledgments to her father and to everyone else for over 18 years on what was conveyed to her by the 1998 gift deed. Elise wants this court to believe that it cannot legally give effect to Lloyd's undisputed intent and must ignore the surrounding circumstances that provide context to this transaction. Elise is not correct. Courts, as you know, as this court has recently done in WTX Fund, routinely look to the circumstances surrounding the execution of a deed for context to discern intent. This family dispute requires the court to construe the 1998 gift deed and the circumstances surrounding its execution. It requires the court to examine and construe the will and any future interest in the Cottonwood Ranch for Lloyd created by the will of his father. And it requires the court to review the record and apply Texas legal principles that are all designed for one core purpose: to ensure that the intent of the grantor is discerned and honored. Time permitting, I plan to focus my argument today on 3 independent grounds for reversing the summary judgment. First, the 1998 gift deed conveyed a lease only a 1/16 fee interest in the Cottonwood Ranch. If you construe the deed, this case is over and Kathy Parker wins on her summary judgment motion. The second independent ground is the summary judgment evidence established that Lloyd did not gift a lease any future interest in the Cottonwood Ranch that Lloyd might later inherit. And third, Kathy's alternative cause of action for reformation, if it is even needed, is certainly not barred by the statute of limitations. Elise claims the 1998 deed from Lloyd gifted her 2 interests in the Cottonwood Ranch. The first interest, which is not disputed, is the 1/16 fee interest in the Cottonwood Ranch, which was half of the interest Lloyd's mother gave Lloyd through a 1990 deed. She also now claims a second 1/16 interest, which is half of Lloyd's future interest in the Cottonwood Ranch from his father's estate that he inherited when his mother died 8 years later. In 1998, that was a future interest because we'll talk about the terms of the will. There was no way to know if Lloyd would ever inherit any interest specifically in that Cottonwood Ranch out of the vast estate of his father. So, did the 1998 gift deed convey any future interest in the Cottonwood Ranch that Lloyd might receive when his mother Ruthie died years later? No, it did not. To convey a possible future interest in the Cottonwood Ranch, that 1998 gift deed must specifically reference that it was conveying that future interest. That is the teaching of Clark versus Gaunt and the other cases cited in our brief. The Clark case was a deed of trust case signed by a daughter that conveyed all of her right, title, and interest, which is language used in our deed, in 2 lots. The daughter owned a half interest at the time in those 2 lots. Later, the daughter inherited the other half interest in those 2 lots when her father died. The court in Clark held the deed of trust did not convey her future interest in the 2 lots. To do so, the court said, the deed of trust needed to specifically reference any future inherited interest to convey that future interest. The 1998 gift deed does not mention Lloyd's future interest in his father's estate. It does not say it is conveying any future remainder interest at all. As a matter of law, the 1998 gift deed did not convey Lloyd's future interest. The quitclaim language used in the 1998 deed, all my right, title, and interest, transferred only Lloyd's present rights in the Cotton Ranch that he owned in 1998. That is the teaching of Clark versus Gaunt and the 2018 Texas Supreme Court case of Perryman that's cited on page 37 of our brief. You will note that there is also general warranty language in the 1998 gift deed. So what is Lloyd warranting in 1998 that he owns title to at that time? Lloyd was only warranting title to the 1/8 fee interest that was deeded to him by his mother, Ruthie, in 1990. That is all Lloyd could warrant title to in 1998. In 1998, Lloyd could not warrant title to some future interest in the Cottonwood Ranch when it was uncertain under the terms of the will if he would ever inherit any interest in the Cottonwood Ranch. An interest in the Cottonwood Ranch was just one of numerous assets in his father's estate. There was the Johnson Ranch, the Mallet Ranch, the Cotton Ranch, other properties, real and personal. And when you have a deed that has both quitclaim language, which really conveys nothing, it says, I don't know if I own anything, maybe I do, maybe I don't, but I'm conveying it, and general warranty language that is in this deed. So you need to construe this case like you'll see the Supreme Court recently did similar language in the ConocoPhillips case to determine what was meant by Lloyd, what was intended with that language, all my right, title, and interest in the Cottonwood Ranch. As the ConocoPhillips case teaches, that language can have two interpretations, and it certainly has more than one interpretation in this case. So the court is entitled to go outside of the four corners. You have to. You can't determine whether Lloyd, what interest he had in the Cottonwood Ranch without going out and looking at the title documents. When you do that, you'll see he inherited, or he was deeded, his mother's interest, which is the interest, as we know from the record, was the only interest he intended to gift to his daughters. So when you look outside of the documents to the surrounding circumstances to determine what Lloyd intended to convey to his daughters, you really can only come to one conclusion. Lloyd only conveyed the fee interest deeded to him in 1990 by his mother. Because to provide a warranty language from this deed with quick claim language and harmonizing those terms, you have to look outside these documents to determine what exactly is being warranted. Lloyd can't warrant title to something he may never inherit in the future. Just can't do it. So to give meaning to that warranty provision as well as the all right title interest, you have to construe it and look outside of it. Because that is all at 1998, all Lloyd could warrant at that time was the interest his mother deeded to him in 1990. Now, Elise argues all right, title, and interest language in the 1998 gift deed also conveyed Lloyd's future interest, even if he did not know it did, and even if he did not intend to convey it. According to Elise, the future interest was a vested interest in 1990, and then it didn't have to be mentioned in that deed conveyance language in order to convey it. However, the terms of the will of Lloyd's father legally defeat this argument. The will gave his wife, Ruthie, the life tenant, special powers, including the power to convey the estate's entire interest in the Cottonwood Ranch or any other property to a family member other than Lloyd. Under Article 3 of the will, found at the clerk's record on page 244, you'll see that Ruthie had the unrestricted right to deal with all estate property as if she was the fee simple owner of the property. That's what the terms of the will say, without joining or even consulting any remainderment. The special powers also gave her the right to alter the equal devolution of the estate and divert any particular asset of that estate to Pamela, Lloyd's sister, who was one of the remainderment, to Lloyd, or their children, or the spouses to their children. So you don't know until Ruthie dies who got what interest in any particular ranch or real estate. You can't know under the terms of this rule because Ruthie has fee simple powers and the ability to direct this to different remaindermen in addition to the two that are initially listed. The spouses of these people. Yes.
Mr. Slavin, if I may interrupt you, I'm just wondering, is the fact that it's uncertain what Lloyd would inherit after, under his father's will, does that prevent him from transferring his interest?
No, it does.
In 1998.
No,
He can transfer, he can convey a future interest. Is that correct?
Your Honor,
A vested future interest, right?
He could transfer any future interest. And I know and that's the point. You're exactly right, Your Honor. If he wants, and why that makes perfect sense to require that to be in the deed is so there's no misunderstanding by a person that I'm giving this interest that I know I have, and then someone 20 years later saying, oh, by the way, you also gave me something you didn't know you had. You gave this future interest away that you you found out in 2006 you gave that away too. And so that's the reason for the rule that yes, you can, even if you just expect your father might give you a house, you can say, I'm deeding you my interest in the house and whatever interest I may ever get by inheritance from my father. The law allows that to happen. But the way it has to happen is it's got to be specifically stated, or it has not happened. I'd submit quick claim language is not enough to accomplish that. And that's our argument. So Texas law is really clear. When Ruthie has unfettered power to deal with the estate property as a fee simple owner without joining or consulting any remainderman, renders any remainder interest in the Cottonwood Ranch a contingent interest, if whether it's contingent or vested even matters. Understand, we say if it's a future interest, it's got to be specifically listed in the deed to be conveyed. But if you think, well, there's a distinction between vested and contingent future interests, then when Ruthie has the unfettered power to treat it as fee simple, the case of Randall versus Estes and Harrell versus Hickman, Supreme Court case, have similar will language that say that is not vested. We don't know who has the interest in the property until the life tenant passes away. In this case, that wasn't the case in 1998. It happened 8 years later in 2006. Second line of cases, some of which Elise recites to the court, says if there is an uncertainty as to the persons who are to take, a remainder interest is a contingent interest and not a vested interest. Caples versus Ward, Clark versus Gaunt, Cavazos versus Cavazos, and other cases cited. And the Caples versus Ward case is an interesting case. And it's what they cite to say, well, just the fact that there's a power of sale that was in that case doesn't change a vested remainder interest to a contingent interest. And what's important is you have to look at what the will terms were that court was construing. In that case, the will had a provision that allowed the life estate to sell some of the estate assets for the benefit of the estate and with the joinder of a majority of the remainder to do so. Compare that and that language to the will language construed in the Harrell case and in the Randall case, which you'll find those will provisions are much broader. The remainderman is not entitled to it. And in those other cases, you knew who the remainder was that might get what interest. The life estate tenant didn't have the power to say, I think I'll convey that cotton ranch to Pamela interest, and while I'll give the other ranch interest to Lloyd. She had the power. You can't tell from the will who is going to get an interest in that specific ranch. And that's the problem. That's the rub. That's why 1998, Lloyd simply could not convey that unless, as Justice Rodriguez noticed, he put in that 1998 deed, I'm also conveying any future interest I may inherit from my father's estate. Had he done that, Justice Rodriguez, you're absolutely right, that could have been conveyed. Although the law doesn't favor those things for obvious reasons, we want to make sure, especially in gift situations, that the people or the grantor's intent on what he is gifting is honored. These daughters paid nothing to acquire these interests. So that makes it important, the gift side of it, to make sure we're looking at all the surrounding circumstances to determine exactly what Lloyd intended to gift to his daughters. And when you do that, you'll see right up front the facts to the lawyer who prepared the 1998 gift deed from his accountant that said, I own a 1/8 interest in the Cottonwood Ranch that I got from my mother in 1990, and here's the deed, and I want to divide that amongst my daughters. And then we get the 1998 gift deed. There is no dispute that Elise received an undivided 1/16 interest, and that is all that she got from that gift deed. So in Randall, as I spoke to about the will, in that case, the court held it was important that the will made no specific disposition to the remainderment of any particular property in that estate. We might have a different case here if the will said, I'm leaving an equal undivided remainder interest in the Cottonwood Ranch to Lloyd. But this will doesn't do that. This will says my wife can operate independent and without knowledge or joinder of these remainderment as if she's the fee simple owner, and she can decide who gets what, all during her life. So it was not until 2006, 8 years later, until we finally find out that Lloyd got this interest. And importantly, on surrounding circumstances, let's look at what happened after 2006 when Lloyd got the interest. Who asserted possession, ownership, and control of that interest? Did Elise? Absolutely not. Lloyd did. Lloyd was signing leases, oil and gas leases for that interest that Elise now claims was hers and had been hers since 1998. Lloyd was paying taxes on it. Lloyd would, and the sisters, the daughters, were also treating that interest as if owned by Lloyd. Those are the types of things that you can consider in construing this deed and what the intent of the grantor was to do it. So the ConocoPhillips case is that was decided recently this year, was a summary judgment case, ConocoPhillips versus Ramirez. And the court in that case construed whether a devise in a will of all my right, title, and interest in a ranch transferred only the surface estate of the ranch as the family understood at the time, or did it also convey the mineral interest of the ranch? The trial court said all right, title, and interest, it conveyed everything, surface and minerals. What did the Texas Supreme Court do? It reversed that summary judgment and rendered summary judgment in favor of the opposing party, stating that it did not, that language did not transfer the mineral interest. Now, how did it get there? It got there by saying that phrase is subject to more than one interpretation, and we got to look at the conveyances before, during, and after that instrument to figure out what was intended. In doing so, they looked at the surrounding circumstances, they looked at the family history of the family conveyances, they looked at the family's belief that the mineral estate was not included in that will conveyance, and the family's subsequent actions, like here, in executing leases, as if the will did not convey the mineral interest. That's how the court reversed and rendered and said that all my right, title, and interest language did not convey that mineral estate because this family has a history and everyone understood what it conveyed, and it only conveyed the surface. Just like in this case, everyone understood, including Elise herself, that that gift deed only conveyed the 1/16 interest in the Cottonwood Ranch that her father got from his mother. One example of surrounding circumstances, there's many in our briefs. If you look at 6 months after Lloyd signed this 1998 gift deed, Lloyd, Elise, and Allison signed 3 oil and gas leases. And as the court knows, you deal with a lot of oil and gas cases, and you know an oil and gas lease is a conveyance. It's a conveyance document of the minerals. So here they are, all 3 signing a conveyance through 3 oil and gas leases of the Cottonwood Ranch, a portion of that specific ranch. And how did Lloyd sign that lease? He signed it both individually and as the remainder of Ruthie's life estate. Well, if he gave away that remainder 6 months earlier to his daughters, why is he and his daughters all signing that lease saying he is the remainder of that life estate? This is contrary to Lisa's position that Lloyd gave her that future interest 6 months earlier. He did not give it away, and she knew it, and they all knew it. I see my time is about done. The brief covers a lot of the issues. I've spent a lot of time on this because this is determinative. I don't think you need to reach any of the other issues in our brief, but we believe that Elise had the obligation to prove a gift, delivery, intent, and acceptance. She didn't do any of those, which would defeat summary judgment. And certainly reformation was not barred by limitations. It was told by everyone, including Elise, operating as if she owed a 1/16th interest. When she changed, that's when the clock began to run, and her mother sued within weeks. Thank you, Your Honor.
Thank you, counsel. Mr. Kaiser.
Thank you, Your Honor. May it please the court. It's good to be in front of this court again. It's been a while since I have. Appreciate the court setting up this Zoom hearing in view of all the circumstances out in the world. Let me begin from a different perspective. In our brief, we rely extensively on the case of Cosgrove versus Cade. It's important at the outset for me to draw the court's attention to a significant statement in that case about the court's policy. I don't often quote cases to other courts, but this time I'm going to. The virtues of legal certainty and predictability are nowhere more vital than in matters of property ownership, an area of law that requires bright lines and sharp corners. That underscores what the court was trying to accomplish in that case. And it set out to enforce that certainty and predictability by announcing a number of bright lines that we believe directly impact this case. Parties are charged as a matter of law with knowledge of an unambiguous deed's omissions, material omissions, from the date of its execution, and the statute of limitations runs from that date. They say that a complete omission, which is what we have here, of a reservation in an unambiguous deed is inherently undiscoverable, which is a fact plainly evident. Now, Lloyd knew he owned this remainder interest. As Mr. Slavin said, he signed leases as a remainderman. He knew that he owned this, and he signed a deed that says, I'm conveying everything. And if you, it's just like in the Cade case, if you refuse or you fail to reserve an important interest like a remainder interest, that is not inherently undiscoverable. A plain omission is not inherently undiscoverable. The court goes on to say that a grantor who signs an unambiguous deed, and this is important, is presumed as a matter of law to have immediate knowledge. And when a reservation of rights is completely omitted from a deed, just like this one, that presumption of knowledge that he's omitted it becomes irrebuttable. So.
Mr. Kaiser,
Yes, ma'am.
at the outset, this is, maybe you can help address some confusion that I have. You know, I fully understand, you know, as my real property professor and described it, you know, obviously we have a bundle of rights. And so we have, you know, present interest in that property, and then we have future interest. The future interest is, the way I understand the law is as a remainderman, that future interest then comes into being, if you will, at the end of Ruthie's life estate. So explain to me how the language that's in this gift deed incorporates, and I understand present interests. Present interests, you've got to completely delineate, you've got to make those reservations, you've got to make those exceptions. I don't disagree with you on that. My question is, if being a remainderment is a future interest, how are we supposed to resolve this if it's a future interest, which is what it is under the law?
I disagree, Justice Rodriguez. Can you hear me? Because you're breaking up pretty badly, but.
Yes. No, I can hear you.
All right. This is not a future interest. And you can label it a future interest, so does, or like they do, to try to pigeonhole it into a restatement or some treatise. But this is, and this is the Caples versus Ward case, which is a Supreme Court case, Medlin versus Medlin, which is a Court of Appeals case, but it was refused back at a time when that meant it had precedential value like a Supreme Court case. And it says a remainder is vested. It's not future.
Wait. Hold on. I'm not talking, let's not talk about vested or contingent. My
All right.
understanding of a present interest is I own Blackacre. I can go and build on that Blackacre. I can do whatever I want, right? I own it. Okay. So a future interest is I have an interest in an estate based on an event that's going to happen in the future.
Which we have here.
Right. So that it makes it a future interest, does it not?
No, that's not what we have here. He was presently conveyed a remainder interest. And the fact that Ruthie might have been able, she didn't do this, but she might
I understand that.
convey that property. And there's some uncertainty as to the amount of the estate that would remain undisposed at the end of her life does not create any uncertainty about the persons that are to take. And
I'm not talking about uncertainty. I'm talking about the definition of a future interest, which is certainly Lloyd didn't have the ability to do whatever he wanted to do with as a remainderman. He didn't come into that interest until Ruthie died, providing she didn't, do something else with those properties. So I still don't understand how his remainderman interest is a present interest, because he can't do anything with that land.
it's because the Caples versus Ward case and Medlin case say it is a present interest. It is not a future interest. Let me just quote the case. It is if there's a person in being who has an immediate right to possession upon termination of the life estate, which we have Lloyd, who has the immediate right to possession at the termination of the life estate. That is an immediate right of present enjoyment, or it's a present right of future enjoyment, and is a fixed interest with only the right of possession postponed until the end of the particular state. It does not matter that she might have disposed of all the property. That in 2006, when she died, that's not when he inherited the interest. And you haven't, but the other side has thrown around the word inherited very loosely. He inherited this interest presently under his grandfather's will. Now, the will gave Ruthie the broad powers to convey this property. And so there's uncertainty about whether he might receive any property at the end, but he has an interest, and all the cases say that a remainder interest like this is transferable and is not a mere expectancy. This is vastly.
No, I understand I understand it can be transferable. I'm not saying it isn't. I think a future interest can, vested or contingent, can be vague. There's no question in my mind about that. But I think what I really don't understand is how a a remainderman has a present interest and not a future interest. So that's what I don't understand.
All I can say is I can refer the court briefing in our brief, Caples versus Ward and Medlin, some of the others. Let me draw a distinction. If I only own a half interest, and I don't, and like in their case, the other case that they cite, the deed of trust case, Gaunt. In that case, she owned a half interest, but her dad clearly owned the other half. She didn't have a remainder interest. She had nothing. And he might have conveyed that to someone else, but she did not have an enforceable remainder right. She had nothing. Later on, when he died intestate and she inherited, then that's when she owned the property. The distinction here is that under all the law that I'm aware of, a remainder interest is an interest of land in land. It's an immediate right of present enjoyment or a future right, a present right of future enjoyment. And it's only future in the sense that possession is postponed. And it can be transferred. Everybody agrees it can be transferred, but does it require any specific language to transfer it? And it does not. It just simply does not. In Medlin, it says the power of sale by itself does not destroy the vested nature of the remainder. And that's all I know to say on that. It's just not a future interest. It is the right, the future right of possession if there's property. And the difference is, did you inherit this interest and can you convey it? Or uncertain about whether there's going to be any property left. And the fact that it's uncertain about whether there's any property left does not make it a future interest.
So how do you define a future interest?
I don't think it matters.
I mean, under your analogy, I don't know that there's a future, so what's a future interest?
I don't know. I don't think that's important. Again, we don't need to label this as a future interest. It is a remainder interest that is capable of conveyance. It's the other side that wants to label this as some sort of future thing. It's not future, it's present. He doesn't know how much property he's going to ultimately get. He can convey that interest. I don't know how to define a future interest, but it's not important to define future interest. That's a straw man to create. Let's try to define future interest and then fit this into that.
No,
the better. And
I think more importantly, I mean, there's no question that there are future interests under the law, property interests. And if this is not a future interest, because that's what it looks like to me, if this is not a future interest, then so my question is then, what is a future interest? And if you can't tell me what a future interest is, then you're basically, to me, dissolving the line between present and future interest.
No, this could be considered in a general sense, future in the sense that he doesn't know what property he's getting, but it's not, it is a present interest.
Okay.
That's
all right.
A future right of enjoyment. I'm sorry. I can't.
Yeah, I think we agree to disagree, but thank you. I appreciate it.
All right. Well, back on Cosgrove, one of the things that is important in that case is that they say that the subjective beliefs about the contents of an unambiguous deed are irrelevant for purposes of tolling the statute of limitations. Let me back up and apply some of the Cosgrove things here. Whether or not it's quitclaim type language and whether or not a warranty is impacted or not. One of the things they say that we say that reformation is required for all of their causes of action. This deed unambiguously except for the disagreement we just had. This deed unambiguously conveys everything he owned. And he owned, if in fact he owned the remainder interest, which he did, it was conveyed by this deed, and he knew it because under Cosgrove, the language is so clear. All of my right, title, and interest to the property without reservation or exception. And a deed, as it's written, is going to convey what it conveys until it's reformed. It passes all the estate owned by the grantor at the time of the conveyance, unless there's a reservation. And until reformed, it's operative. So in very, very simple terms, the 98 deed said, okay, you own a remainder interest, whether he knows it or not, but he knew it. I convey to my daughters all of my right, title, and interest. That remainder interest was not reserved, which is a fact.
Mr. Kaiser, I'm going to ask you to stop just a minute. It's 10:10, but I don't see the other justices.
Oh,
Hold on. I know it was. I think we lost them. Hello, Judge Alley, Judge Palafox? Missy, will you take note of the time and check on Judge Alley, please? Like I said, we've been having issues this morning with everybody. So, and it's not necessarily the court. We lost one of the lawyers in one of the other arguments that had to come back in, but for whatever reason, it looks like we've lost Judge Palafox and Judge Alley. Let me check. Our timekeeper's office is just across the hall from Judge Alley, so I'm sure she's gone in there to check. She stopped the clock for us. The only question I have, because is whether or not we have to sign out and come back in. Let me check. All right. Apologize for that, gentlemen.
No problem, Yuri.
No. Can't be the weather, right? It's beautiful outside. There we go. Let's see what happens.
aha.
There's Judge Palafox. You just need to,
Yay, welcome back.
I think let me unmute her.
There you go.
There you go. Can you hear us, Judge?
Yeah, I'm sorry. Even when I tried to log back in, it was frozen, so I had to reset everything.
Oh, no. Well, we're waiting on Judge Alley. We stopped the clock, so we're waiting on Judge Alley.
Okay. But are you now the host?
I don't, I don't know. thought Liz was the host, but I don't know. I told Missy, and so she stopped the clock, and I asked her to go and check with Judge Alley, and so anyway, and I sent all of y'all an email. So let's just wait and see, because I thought Liz was the host.
No, actually, Judge Alley is the host
Okay,
on the oral arguments. Well, actually, on all the meetings. I only do the sound and video check, but
thank you, Liz.
he is trying to log back in.
So okay,
Yay.
There he is.
there you go. Yes.
Judge Alley, we can see you. Can you
Oh,
hear
no.
us?
Yes, I can hear you.
Okay.
Okay, this has just really been our day. Mr. Kaiser, I noted that you had 11 minutes and 10 seconds left when I froze up. I'm sure you remember exactly where you were in your thought train.
All right.
And I apologize for that. So
Problem.
you can go ahead and start the timer, but I'll note that you can go a couple minutes over. That's fine if you need to.
I probably won't need to. Are we ready?
I am, yes.
All right. Not sure where I was, but assuming,
Okay, can I ask you, I'm sorry, Mr. Kaiser, may I ask you another question? I want to be sure, I think you've already told me this. So you're looking at Caples v. Ward and Medlin for the proposition that a remainderment interest is a present interest as opposed to a future interest.
that's two of
Those are
the
your two best.
cases. There's
Okay, I
others
just,
in there.
okay, no, that's fine. Thank you. I appreciate that.
Yes.
I apologize. Thank you.
No problem. Okay. Let me talk for a minute about mistake as to legal effect. Assuming that the remainder interest was conveyed and that was a mistake, does Cosgrove bar it by limitations? Sometimes there are some cases that say if it's a legal mistake that maybe the discovery rule applies. Here, I don't know how it can be a legal mistake by Lloyd. And as a layman, he knew he owned the remainder interest. He maybe didn't intend to convey the remainder interest, or he made a mistake in not omitting it. But how can someone be mistaken about the legal effect of the word all? All means all. And all my right, title, and interest, whatever I own, I'm conveying. And he knew the same mistake had been made in 1993 in the deed from his mother in 1990 and 93. There was a deed from his mother where he got this eighth interest in the ranch. And his mother conveyed that to him with a deed that said all my right, title, and interest. And then it dawned on her or her lawyers or both that a conveyance of all my right, title, and interest to Pamela and Lloyd would have the legal effect of conveying the life estate, much like the legal effect of conveying the remainder interest here. And she made Pamela and Lloyd correct that with a correction deed that recognized that all meant all, and she didn't mean to give them all. So a few years prior, Lloyd had been faced with this exact legal proposition. He knows he owns an interest. There's a plain failure to accept it. And that it had legal significance failing to do that because his mother said, I'm correcting this deed to make it clear I'm not conveying my life estate. And Lloyd had 4 years to do that. But let's suppose that the discovery rule applies somehow. Even if the court were to apply the discovery rule, limitations under the legal mistake rule begins to run when Lloyd discovered the legal mistake, the mistake in his failure to understand that all meant all. All my right, title, and interest broadly conveyed everything he owns. And when does that happen? It happened in 1993. That's the date he understands that this kind of a legal mistake can be made. So even if the discovery rule were to apply, which we say it does not under Cosgrove because of the presumptions and the bright line rules, that he knew of this legal mistake. As to donative intent, donative intent should be judged at the time of the conveyance. And I'll hurry through this, but the 1998 deed itself shows Lloyd's donative intent at that time. It conveys all his right, title, and interest. All means all. And when a parent makes a gift to a child, donative intent is presumed. When a deed is signed, acknowledged, and recorded, a presumption arises that the grantor intended to convey the land according to the terms of the deed. And those presumptions satisfy our burden of proof. Did they conclusively prove that his intention were otherwise in May of 1998? They did not, and they do not contend that the deed itself is somehow invalid, or that it wasn't delivered, or wasn't accepted, or there wasn't intent. And the nuanced arguments on the law that all of us are making about whether he could legally convey this interest or not, he knew he owned this interest. His grandfather's will said he did. It says it in very present terms. I give in undivided shares a life estate to Pamela and Lloyd. So the experience with the 1993 correction deed informed Lloyd of the legal effect. And so, how did they conclusively show? Conclusively show that in contradiction to the unambiguous terms of this deed, where Lloyd conveyed everything he owned, all means all, that his intention were otherwise. Well, they offered some evidence of people after Lloyd died. Of course, Lloyd is dead and we can't ask him. After Lloyd died, people say, this is what Daddy meant. This is what my brother-in-law meant. This is what he understood. This is what he knew. All conclusory and speculative evidence that is not competent summary judgment evidence. But we have clear language in the deed. Even Lois Capp's testimony, the accountant, she ultimately concedes that even though she tried to say, I believe he knew this or didn't know that, she ultimately said, we really never even talked about it. So I think the court should acknowledge that the policy reasoning behind Cosgrove in the Cosgrove case spills over somewhat into this, because certainty of land titles and predictability of land titles shouldn't hinge on what someone thinks the grantor knew who's dead and believes he understood. We ought to look at donative intent, and we ought to look at legal mistakes in the light of the plain, what the grantor knew he owned, and the plain language of the deed. I'm going to give the court back some time before I wink out again. And I'm going to say that we believe that the brief covers mostly everything else. And unless the court has more questions, I appreciate it.
Thank you, counsel. Mr. Slavin, do you have any rebuttal?
Yes, Your Honor, if I might. Let me start with all means all. I think you heard that said 3 or 4 times. And the Texas Supreme Court this year in January 2020 defeats that argument. ConocoPhillips versus Ramirez was a family will dispute over ownership of surface and minerals of a ranch. The court considered whether language, all my right, title, and interest, sound familiar, to the ranch, only conveyed the surface estate as the family understood at the time, or also includes the mineral estate. The trial judge said all means all. All means all. It's the whole range. It's the surface and the minerals, and granted summary judgment. And this year, what did the Texas Supreme Court do? It reversed that summary judgment and rendered all does not mean all. In this circumstance, under the history of the cases, the conveyances, everything they looked at. Look at that case. It's a short case, but it's an important case. All does not mean all, because we are going to look at the entire conveyances involved in this, the intent of the party. It was a will devised, and they're going to determine what really was intended, because that's what the goal is. We have rules, we have principles. They're all designed for one purpose, to make sure we enforce the intent of the grantor who made the gift. Now, the rare time that falls through the crack, we don't like it, but sometimes it can. This is not one of those cases. This is a case where the law supports the only gift that Elise got 18 years ago or more was a 1/16 interest. In that case, the court noted the phrase, all my right, title, and interest was subject to more than one interpretation. That's what the Supreme Court just said. That's not what you just heard. That's what they looked at. And they looked at the history of the family conveyances. The family's belief at the time the will did not transfer the minerals, and the family's subsequent actions, just like in this case, where they executed mineral leases that as if the will did not convey those minerals. Just as Lloyd is executing mineral leases as if he did not convey that remainder interest. I mean, it couldn't be closer to what you're considering today, and it absolutely defeats their claim. Now understand, they go right to Cosgrove, and don't be confused. Cosgrove was a reformation case. We don't reach reformation in this case until it's an alternative claim if you construe the deed differently than we say you should. There is no statute of limitation on her trespass to try title claim, as the court knows, unless they get it through adverse possession or some other way. You can't just take someone's property away from you when it's a trespass to try title. And that's the first claim we have in this case. So Cosgrove was a limited exception to the discovery rule that generally applies in a reformation case. And it's a limited exception only for plain omission cases. And what you need to understand about Cosgrove is it started out, it wasn't a gift, it was a sale, a piece of property, the entire property, a sales contract. And in the contract, it said the seller is going to reserve the minerals. But when they did the deed, they just conveyed the property. It was not an all my right, title, and interest quitclaim language. It said the fee interest is going to you. And the contract, everyone knew, was going to reserve those interests. The deed did not include the reservation. The court said this is an exception to the discovery rule of tolling, and we're going to say it began running when you signed that deed, because it didn't include that reservation that you included in your contract. Everyone knew that needed to be reserved. This case is not a plain omission case. This case is like the Texas Supreme Court case of McClung versus Lawrence that's cited in our brief. And the McClung case, what did it do? It was a reformation case that was filed 16 years after the deed. Almost like 18 years after the deed, as we have here. And this is only if you get to reformation that you would even look at that. So Cosgrove, it doesn't apply. McClung versus Lawrence says mistakes by parties about the legal effect of the deed conveyance language are not plain omission cases, and the discovery rule applies. Is this case all my right, title, and interest, and then a general warranty? Is this case something where there is confusion about the legal effect of what is being conveyed? Of course it is. It is not a Cosgrove case where they sold property and everyone knew something needed to be reserved and it was in the contract. This is a case, We have for 16 years title opinion attorneys opining that that 1998 gift deed only gave a lease a 1/16 interest. Is that plainly evident? No, it is not in the family of Cosgrove, which are limited cases. It is in the McClung versus Lawrence and the several cases we cite, I think on page 58 of our brief, 57 to 59. Several cases, you will compare the facts. You will see those facts are what apply here. And what specifically on tolling about Elise's conduct are found in those cases, one being Sullivan versus Barnett. It's a 1971 Texas Supreme Court case. And what the court said is, look, we're not going to let someone say for many years that I only own a 1/16 interest and then abruptly change positions and say, it's too late for you to reform or do anything about it. Sullivan said, and the other cases cited in that case specifically say, we're not going to let you lull a person into a sense of security and then do that. Everyone, title attorney opinions, third parties, Lloyd, Elise, Allison, all construed the gift by that 1998 deed for 18 years as conveying a 1/16 interest to Elise. It was not until she changed positions, and how long did it take for her mother to sue to construe this deed and to determine what was gifted, and if that didn't work, to ask to reform it, to get to Lloyd's clear intent, as is evident from the lawyer, from the note to the lawyer on what he's supposed to do. 5 weeks. Tolling didn't stop a reformation claim, but we'll never get there, I don't believe, if you apply the same standard that the Texas Supreme Court just applied in ConocoPhillips versus Ramirez to this case. If you apply that Ramirez case to this case, you can only reach one conclusion. The only thing that deed gifted to Elise was the 1/16 interest she acknowledged multiple times in multiple documents. Lloyd acknowledged in multiple times in multiple documents was what happened. As the Texas Supreme Court I'm sorry, Your Honor.
I'm just going to ask you, you said ConocoPhillips versus Ramirez?
Yes, ma'am.
Okay, thank you.
It's a 2020 case. It's cited in our reply brief, Your Honor.
Okay, thank you.
Sorry, I don't have the exact.
No, that's fine. That's
Sorry.
fine. Thank you.
But look at that case and you will see, counsel talked about subjective disputes on what Lloyd owned. Look at the Piranha case, the Piranha Partners case, another Supreme Court case that came out this year. And what Piranha said was, it talked about looking at, and let me get the quote right, objectively determinable facts and circumstances that contextualize the party's transaction can help clarify the party's intent. I'm not citing to you what someone said Lloyd said to him. All you have to do is look at the 17 or so documents signed by Lloyd and signed by Elise for 18 years, over the span of 18 years. Every one of those was Elise got a 1/16 interest. The gift tax return for 1998, right after he gave the gift, said he gave her a 1/16 interest. The leases, the documents, the partnership where they managed the ranch, she was credited with a 1/16 interest from 2001 to 2015. And that's what managed the Cottonwood Ranch. One last thing with my few seconds I've got left is don't confuse.
You're actually over your few seconds. If you could wrap up, please.
Oh, sorry. Don't confuse a remainder in this entire estate with a remainder in the Cottonwood Ranch. It is one of 3 ranches in this estate. The will does not give Lloyd an interest in a remainder interest in that Cottonwood Ranch. The will lets his mother decide what person is going to take. So there, as even in Caples, there's no certainty as to what person is going to take. And Capel said that makes it a condition preceding, makes it contingent and not vested. Thank you, Your Honor.
Thank you, counsel. Thank you both for your excellent argument and briefing in this case. And we will get back to you just as soon as we can.
Thank you, Your Honor.
Thank you very much. Stay safe.
Have a great day.